Breaking news I said the Supreme Court had dismissed Kojo Oppong Nkrumah petition or the command the Supreme Court say legal vacation are certain cases is unconstitutional. And I say a Supreme Court on have a certain view on it. The court has dismissed it. But it's not just the dismissal, it's the interesting perspective say about Kojo Oppong Nkrumah and Kasa. The lawyer or the court Frank Davis, for those who don't know, that's kind of Frater's lawyer. I'm in the office. But there's some interesting angle because one of the issues by and they say, can the Attorney General actually be the lawyer for the Chief Justice? Yes, you know, in the matter. There's an interesting angle where my lawyer, Clement Okokujo, is in media branch post, and I read it for you and explain. Because if you ever say, Kojo Oppong could sue Chief Justice. Chief Justice is being represented by Attorney General. Attorney General is also an interested party in the case. One crowd of court to the case in the so is there a conflict of interest? There's an interesting legal perspective for that the ruling is not about when I go when there's a full ruling, I'll do it for you. But and the explanation of what it means, I'll share my view on it. And then what I also make of the ruling, I'll share it with you. And to make sure so subscribe, most subscriber not keep your notification with the video we are to make sure you have a comment, feel free, leave that comment in the comment section. Make sure so we could Goldberry Construction Limited, other episodes in Wasase and Krata sub documentations related to your house in the Goldberry. It be this age money Nadia Ma, we are back with myself, so project in Ghana be a school. Whatever activity engaging in Ghana, here we are fed better particular to go on the field, check the facts for you, send you pictures with your visuals for you to see what your money is being used for. Back with myself, be this age money now. In legal vacation about. And the Chief Justice a warrant for certain cases to continue. Now, Kojo Oppong Nkrumah disagreed with the Chief Justice and went to the Supreme Court to say that action by the Chief Justice is unconstitutional, and that when it comes to constitutional matters, Article 130, if my memory says 1302, meaning constitutional, but I think it's 1302. When it comes to matters of interpretation of the Constitution and also constitutional matters, is vested in the Supreme Court, which is our apex court. Now, when he went to court, one of the issues that came up is this thing on the screen, where it says that AG cannot represent Chief Justice in vacation trial case. Now, Justice Bawumia tonight as a single judge on the case. That's interesting. So, unlike Supreme Court, we are 3-5 judges now because of the peculiar nature of the legal vacation. Only one judge sat on the matter, Justice Gabriel Scott Bawumia. Now, when I was trying to get understanding why, because I was also confused, why the Attorney General, because I know that the Attorney General articulated the principal legal advice of government, and the judiciary is a subset of government because it's a tripod. So the executive, the legislature, the judiciary. So it's a tripod. So he can represent. But some also, okay, he's also an interested party in the case. So won't there be a conflict of interest? Now, Justice Bawumia dismissed it. Now, when he dismissed it, it became an issue. So, we're dismissing the answer. So, people were speculating. Now, when Kojo Oppong Nkrumah by any education. Now, the lawyer directed me to read from the gentleman. He's a lawyer, I'm told, in the legal preference. It's called Cephas Bapuri. This is what he had to say, and I'm reading for it. I'll explain. He says that this matter appears to have received some answers from the Supreme Court, Tatuchikata versus Chief Justice and Attorney General, where a similar objection was raised. In that case, Tatuchikata sued the then Chief Justice. The Attorney General at the time, Nana Akufo-Addo, represented the Chief Justice on the basis that the suit arose from the performance of his public duties and therefore fell under within the mandate of the Attorney General under Article 80 of the 1992 Constitution. The concern was this: the Chief Justice is a member of the judiciary, which is constitutionally separate and distinct from the executive. The Attorney General, on the other hand, is a Minister of State, and under Article 88 serves as a principal legal advisor to the government. It is therefore arguable that the Attorney General's representation of the Chief Justice poses potential breach of the principles of separation of powers. Professor E.V. Dankwa Esquire, who represented Tatuchikata, argued that on the principle of separation of powers, it should not be seen or appear to be seen from the executive organ of government was interfering with the judiciary. He further contended that although both the Attorney General and the Chief Justice have been sued the acts contained of against the Chief Justice were done in his personal capacity, and therefore the Attorney General had no responsibility to defend them. It followed in his submission that the affidavit verifying the content of the case, the statement of the case filed by the defendants ought to have been sworn to personally by the Chief Justice and not representative of the Attorney General's office. However, the Supreme Court found the above analysis too simplistic and not reflecting true operations of the constitutional principles of separation of powers. The distinction is important. If the Chief Justice is sued in his personal capacity arising from acts that are personal to him, he must engage a private legal practitioner. However, when he is sued in respect of the act performed in the discharge of judicial or official functions, he is acting in his capacity as a public officer, and the state must afford him legal representation. If you care, this was how His Lordship Ampia JSC then put it. There is no doubt as to the position of the Chief Justice. He is a public officer appointed by the President, acting in consultation with the Council of State and with the approval of Parliament. It is not disputed that his official act, that is, act performed in pursuance of his functions of office, are official act, and Article 885, therefore, any attack on him in the performance of his duties need to be defended by the Attorney General on behalf of the state. So that the thinking of the Supreme Court then, when Chachuchi Kata was also prosecuting a case, and it was against the Chief Justice then, and Akufo-Addo then, President Akufo-Addo, who was the then Attorney General, was represented, the Supreme Court said that the performance that the Chief Justice is performing is based on his functions as a Chief Justice. It's not his personal function. So therefore, the administrative fiat or warrant giving judges of the Supreme Court, High Court, Circuit Court, whatever, to operate within a legal vacation is an administrative function of a public officer who is an officer of the court and a member of government, because the judiciary is a subset of government, and therefore, in pursuant of that act, he falls under the legal representation of the Attorney General, and therefore, if someone believes that that action must be questioned, he must be defended by the state, and the chief principal legal advisor of the government is the Attorney General. Now, Justice Mahama went to that same school of thought, but the ruling is not public. The ruling will be contained in the final ruling that will come as part of any case now to dismiss Kojo Oppong Nkrumah. He also dismissed it, largely saying what Kojo Oppong Nkrumah said in this video.
The court has dismissed our injunction application, but in the ruling, some very interesting pronouncements have been made. For the first time, the courts have admitted that some cases are being treated differently. Those are the words of the judge.
And expeditious.
They are being treated differently and expeditiously. Why? He doesn't say so. But then he proceeds to say that, in his opinion, that will not amount to a violation of the constitutional articles that we have raised in this particular matter, and that he thinks that that will even be in the interest of the accused persons. We've asked for a certified copy so that we can peruse it some more, and then on the advice of counsel, we'll take the next steps.
It means that you are open to applying for a review?
Very much so, but we'll consider it. I'll leave it to
but would you say you are not satisfied
Frank.
with the...
I'll leave it to Counsel Frank to make a few comments.
Frank, do you consider that the decision is fair?
Well, as trained officers of the court, when you come to court, with an anticipatory mind. When you have an injunction application, whatever application you have before the court, is either will be refused or will be granted. So yes, the judge has made a determination. It is not in our place as lawyers to condemn the judge. We can only critique. The plaintiff has told you in very short terms his understanding of what happened in the courtroom. So we will abide the ruling of the court for now. We are not giving to say the things other lawyers say when decisions of the court are handed and doesn't go in their favor. We will not repeat those chants because they don't sit in our usual lexicon as lawyers. So yes, we accept the ruling of the court for now. We have applied for a certified true copy of the ruling, which the registrar has promised so to do. But I insisted that we have the ruling by 2 p.m. So we shall apply for, when the ruling is handed to us, we shall read in detail the reason ruling and appropriately advise our client.
It was quite a lengthy and detailed one. Do you consider that the judge perhaps went into the substance of the matter? For instance, when he says that the plaintiff of Kojo Oppong Nkrumah does not disclose a serious constitutional issue to be determined by the Supreme Court.
You want to enter my head through my mouth. I just spoke to you, and I spoke very fluent and simple English.
Thank you.
Yes. So basically saying that the Chief Justice has the warrant to do that and the cases can continue and all that. It will be interesting to read the ruling, but based on my principle when Ora started, I'm one of the few people who have consistently said that when it comes to corruption cases and the way it travels, look at Saglebe. About Collins Adama, 8 years. A case, Bawumia. A issue case, Kojo Oppong. Political cases now say again, and even in some of these oral cases, you've seen some rulings I disagree with, and how the judges believe that those motions brought against them should be accepted. But they are the law laws. That's how we say you can disagree, but to attack them. So they are the law laws. They are the bastion of the law. They have to interpret these things and all that. But I think that maybe that colonial relic must be relooked at. I don't understand why for 2 cases, major cases of national interest, major corruption cases should be put on hold because of a legal vacation. There can still be the legal vacation, but we can find room and say that for certain corruption cases, for certain cases where that's why the state can make some meaningful returns. And when you say me the ora there, me JJ some no, me wait me the matter on that, I don't care. Me there be recoveries, no. And I brand you are pay make on there, but 2 years we need to manage. Oh dear, when we cover some of these money, they'll be able to do some work and all that. So I believe that we need to look at that colonial relic and work around some of these things. So it will be interesting to see what the full ruling will say. But certainly, when the full ruling breaks, not on the critical analysis, we do that for you. Even from not familiar grounds, we do it for you. So I'll certainly do that for you. Forgive me if the sound is not that clear because of my voice and everything. But as I get home and I get more details, I'll break it down for you. It's a breaking news. That's why I have to do this. So that's so shady. Leave your comments in the comment section. Yeah, not subscribe. I'm subscribe. I'm not clicking on notification. If you do be at my video, make sure somebody shows you them on me. Ghana, bye bye.